Picture this. It's February 5th, 2025, and a ripple of unease travels across businesses nationwide. A new Department of Justice memorandum has just been issued. Behind its carefully worded directives lies a seismic shift, one destined to reshape the field of U.S. immigration enforcement. Many employers of H-1B visa holders are suddenly asking themselves an urgent question. Are we prepared for what's coming? Attorney General Pamela Bondi's announcement isn't just words on paper. It's a mandate for heightened scrutiny and tougher penalties. The clock is ticking. But what does this really mean for America's businesses and the countless immigrant workers they rely on? Let's dive in. The DOJ memorandum, effective immediately, prioritizes the aggressive enforcement of immigration laws. That means federal prosecutors are being directed to pursue immigration-related offenses with unprecedented vigor. Employers of H-1B visa holders are now squarely in the crosshairs, facing the likelihood of unannounced audits, site visits, and even criminal charges. Let's start with what makes this memo different. In the past, most infractions were handled administratively, visa revocations, civil penalties, that kind of thing. But this new directive? It's calling for the expansion of criminal law. Make a mistake with hiring documentation or knowingly employ unauthorized workers, and you could find yourself in court, not just paying fines. Under this tightened regime, even minor errors on forms like the I-9 employment eligibility verification could lead to serious legal headaches. The memo also authorizes prosecutors to use broader tactics like charges of fraud or conspiracy, aiming to dig deeper into employer practices. Compliance isn't just paperwork anymore, it's a lifeline. Think about it. How prepared are most businesses for an unexpected audit? Imagine a team of government officials showing up unannounced, scouring payrolls, combing through hiring practices, and asking tough questions. It paints a stark picture, doesn't it? The impact doesn't end there. Recent updates to the H-1B visa program bring even more changes to manage. On January 17, 2025, the Department of Homeland Security introduced stricter guidelines to the program. Among them, a revised Form I-129, the very document employers use to petition for non-immigrant workers. And here's the kicker. There's no grace period. Employers must switch to the updated form immediately or risk non-compliance. These reforms also shift focus to the intended beneficiaries of visa applications, promoting fairness but forcing employers to navigate new layers of accountability. Plus, enhanced verification measures make the registration process tougher than ever. Running afoul of these changes could bring the weight of federal oversight crashing down. So what are employers to do? Where do they even begin? The top priority is compliance. Employers should review their recruitment and hiring practices with a magnifying glass. Are systems in place to ensure every single step adheres to immigration laws? Have I-9 forms been audited? Are teams fully trained on the intricacies of work authorization requirements? If the answer to any of those questions is no, the time for action is now. Training programs for staff have never been more essential. Think of it as a preemptive defense strategy. A single error, even an unintentional one, can trigger investigations. Updating employee manuals and policies to reflect these new realities is no longer a nice-to-have, it's a must. But wait, there's more. Employers also need a plan for enforcement visits. That's right, unannounced audits are on the rise. Having a response team ready to address such situations can mean the difference between compliance and chaos. And let's not forget legal counsel. Ongoing guidance from immigration experts isn't just a smart move. It could end up being the safety net that keeps a business out of serious trouble. Now more than ever, businesses need to be proactive, not reactive. It's clear that the memo from Attorney General Pamela Bondi signals a turning point. Employers are being asked to rise to higher standards at a faster pace. And the stakes? They've never been higher. Could this be the dawn of a new era in immigration enforcement? One where employer missteps, no matter how small, bring swift and severe consequences? The DOJ seems to be telling us yes. As we close, let's consider the broader picture. Businesses are the backbone of innovation and opportunity in America, and immigrant workers play a vital role in that story. But with the DOJ's new memorandum and expanding collaboration with agencies like DHS, the rules of the game are changing fast. Employers must act decisively, reviewing practices, strengthening policies, and seeking expert advice. The alternative? Fines, lawsuits, even criminal charges. But here's the bright side. Compliance isn't just a challenge, it's an opportunity to future-proof your organization and strengthen trust. The new chapter in immigration enforcement is unfolding before our eyes. Will businesses stand ready or fall behind? After all, in this high-stakes environment, preparation isn't optional. It's survival. Learn more about this and other immigration updates at visaverge.com.